Okay, we are live. So hello, everyone. So happy to be back today. We are here with episode 3 of our new Facebook Live series called Poultry Cracked Open, How Agribusiness Giants Exploit Small Farmers. Today's episode is called In Defense of Farmers, Strengthen the Packards and Stockyards Act. And we just want to open by thanking everyone for joining us. We really appreciate all of the support and just the folks that are here to learn and listen and support us in this cause. While we're waiting for people to hop on, I'll go ahead and introduce myself. My name is Julie. I'm the communications manager for SRAP, and I will be moderating today's conversation. I'd like to give a little bit of background about SRAP and its mission while we're waiting for folks to hop on. As many of you may already know, consolidation in the poultry sector allows agribusiness giants to manipulate the marketplace. This reduces farmers' earnings, making it difficult for them to make ends meet. Unchecked consolidation, where corporations control multiple stages of the production process, has created an imbalance of power, which allows industry to manipulate the marketplace, trap farmers in exploitative contracts, push down the prices paid to farmers and ranchers, and also drive independent producers out of business. So in today's Facebook Live, we have 2 former contract poultry growers who now serve on SRAP's field operations team. And they're going to be discussing how the Packers and Stockyards Act of 1921 was created to protect farmers, ranchers, and growers from abuses by meatpacking corporations. We do have, you may notice that one of us is missing today. Miss Susie Crutchfield is feeling a little bit under the weather, so unfortunately she won't be joining us, but she'll be back for episode 4, so be on the lookout for that. Today, our guest will also be discussing how the USDA and its proposed changes to the law could strengthen its ability to protect farmers from deceptive anti-competitive practices. And we're really excited because we have a special guest, Aaron Johnson. He is the Challenging Corporate Power Program Manager for RAFI. He's going to give a deep dive on the history of the Packards and Stockyards Act, share updates on recently proposed changes to the act, and also how growers can get involved with the advocacy surrounding this law. And then just real quick, before we dive into our conversation, we want to remind folks about SRAP has a contract grower transition program, which helps transform rural communities by engaging contract growers struggling within the industrial ag system. So if you are a contract grower in need of assistance, please contact us at the link in the chat, which we'll be putting in there shortly. Also, SRAP helps protect communities from factory farms. So through education, advocacy, and community organizing, SRAP helps people protect public health, environmental quality, and local economies from the damaging impacts of factory farms, and to advocate for a socially responsible food future. So if you need help protecting your community from a factory farm, you can call us at this number. We'll put this in the chat too. It's 503-362-8303. Okay, I think we're ready for introductions. So we're here with Craig Watts, Michael Diaz, both who are former contract poultry growers who now serve on SRAP's field operation team. They're also part of SRAP's contract grower transition program, which looks for ways to help contract growers leave the industrialized poultry system behind. And then we also have our special guest, Aaron Johnson. And with that, I think we'll have Craig introduce himself first.
Sure. Thank you, Julie. Yeah, my name is Craig Watts, and I'm down here in southeastern North Carolina, and I'm a former contract poultry producer of 23.5 years. Just over time, just kind of got a little disillusioned with the business, a little philosophical difference between me and the industry. So I decided to exit in 2016. where I joined up with SRAP as a consultant, and then a year and a half or so ago, actually joined the staff team as a field operations director. Michael.
Thanks, Craig. My name is Michael Diaz. I too am a former contract grower. Was able to find out really quick that the business model that was presented to me and my family wasn't a model that was going to support us. So we were forced out of the system. Thankfully, with help from organizations like SRAP and Craig and Susie, who's not on the call, they were a family that gathered around us and provided some support to just help us navigate an exit. So with the contract grower transition program, we aim to engage contract growers who are struggling in the system and hopefully offer them some ways to exit and give them some opportunities to look at doing things different. Aaron.
Yeah, I'm Aaron Johnson. I'm the Challenging Corporate Power Program Manager at the Rural Advancement Foundation International, USA. RAFI does a lot of work with a wide range of farmers, ranchers, and other agricultural producers. And among that, those different projects, we do federal policy advocacy, and we've been working on issues related to contract poultry and contract agriculture for decades. We've been involved in all of the landmark fights around the Packers and Stockyards Act really since the turn of the 2000s. And my program, the Challenging Corporate Power Program, is focused on doing policy advocacy to reverse trends of corporate concentration in the food system, specifically related to the livestock industry. We see runaway corporate concentration in really every sector of the food system. And so we work with the legislative branch, with the executive branch, with really any kind of policymaker that's working on these issues to advocate for policies that will return, the power and control over the food system back to local communities.
Julie, I'd like to give a little background of the PSA before Aaron gets into his, but I would like to talk a little bit about my history with RAFI and the PSA. This RAFI has been working on these issues for at least since the 80s. There was a lady named Mary Klaus, and she just walked in the office one day and told these problems that they were having in the contract poultry business. And you can fast forward 40, 50 years later, and we're still having these issues. I got aware of RAFI in the 90s when we actually had a North Carolina contract Poultry Growers Association and a national association. They were both pretty strong, and they would send out a newsletter every once in a while, and there would be some excerpts in there from the folks at RAFI. And so just kind of loosely work with them a little bit. But then around the 2008 Farm Bill, when the livestock title came in, what eventually became the GIPSA rule, what we're talking about today, the Packers and Stockers Act reforms, I got really involved and did some hill visits with RAFI. And I'm just telling you, they are the original OG when it comes to helping contract poultry farmers out. So you guys cast a bigger shadow probably, Aaron, than you realize, because Michael Diaz, I actually met him working through the farmer helpline at RAFI. Susie Crutchfield, if I know you've seen the movie Under Contract, well, she's in it, so she has been involved with RAFI too. So man, just excited to have you today, and excited that the news that you're going to bring us here in a few minutes. But just to give a little history on the Packers and Stockers Act, it goes back to 1921, and I'm thinking it's Woodrow Wilson. But it was just a response to public that had concerns about the consolidation these meat packing industries were getting and the control they were having. So the Packers and Stockers administration was founded as an agency to enforce these new laws they came up with. In 1935, live poultry became a part of the PSA. Now, there is a little quirk here with live poultry that we run into today, and that is the fact that the farmer doesn't own the chicken. That kind of throws a little monkey wrench into the whole deal here. And Aaron, you may get into that a little bit later, but I will let you do that. So over the last several decades, the concentration in the meat packing industry has just gotten worse. And at the core of this is these confined animal feeding operations, or CAFOs, and where there's thousands and millions of animals crammed into just this tiny little housing on very few acres of land. And so that also gave up rise to vertical integration, which we're talking about poultry today. And poultry is the most vertically integrated species out there. So that, I mean, basically the integrator, they control everything from the egg to the shelf and all points in between, except for one thing. They don't control the farm, and there's absolutely a reason for that. So yeah, the Packers and Stockers Act would then merge with the Federal Grain Inspection Service in 1994. That's probably about the first time I'd ever heard any mention of a Packers and Stockers Act, but it became known as the Grain Inspection Packers and Stockers Administration. That's a mouthful, so we just call it GIPSA from now on. And that agency was charged with enforcing the PSA. So like I said, in 2008, Congress actually charged the USDA in the Farm Bill to address some of these issues that they had been hearing for decades in the relationship between the farmer and the processor or company, or they use the term integrator. So I was really involved with that. In 2010, we all went down to Normal, Alabama, and they had a USDA DOJ hearing, and we all got to stand up and testify. And there was some pretty high brass there. I mean, there was the DOJ guy, Tom Vilsack was there at the time, the head of GIPSA, and a few more deputy administrators. So we were feeling pretty optimistic at the time. But what happened was, when those proposed rules came out, the companies really pushed back. They lobbied to get the comment period extended from a normal 60 days. I think they went out 6 months. So that gave them time, I guess, to get out their checkbooks or whatever, make some, influence some politicians. But at the end of the day, it got watered down, and then nothing really happened. And so they, instead of go ahead and writing the rule, Congress actually did something called a GIPSA rider, where they actually would not fund the USDA in finalizing that rule. They didn't get away with the rule, but if you don't have any money to write it, it's as good as dead in the water. So after, I don't know, a couple, 3 more years, finally, when Obama was going out and Trump was coming in, they had this thing they called the Farmer Fair Practices Rule, which was going to deal with the deceptive and exploitative behavior. And it kind of still is there, but the problem is what they came up with was, if this is normal industry practice, it's okay. Meaning they were hoodooing farmers, before this law was written. So if they continue to do it, it's okay. So that's the thing we want to see changed, and that's hopefully the good news Aaron is going to bring us right now. So I'm going to turn it over to you, buddy. Thank you.
Cool. Thanks, Craig. Yeah. So I think that's a great overview of how the story of the Packers and Stockyards Act and its enforcement has played out over the past few decades. One of my favorite stories about the Packers and Stockyards Act, actually, just to get us started, we're about 100 years removed from when our country was struggling through forming this legislation and these rules for the meat industry. And at this time in 1919 and 1920, the meat industry was similarly concentrated. About 80% of meat production was controlled by 4 companies, and the FTC at the time did a pretty wide-ranging investigation of all of the ways that those companies were manipulating the market and exercising their monopoly power, their monopsony power. Just really quick, monopoly power is your power over your ability to sell things without competition, and monopsony power is your ability to buy things without competition or set prices. And both of those are problems. And so the FTC did a big report in 1919. They actually recommended that the meat packing infrastructure in the United States, so processing facilities, stockyards, be nationalized and turned into public utilities. The compromise that eventually evolved out of that process was the Packers and Stockyards Act. The meat processing plants and stockyards weren't nationalized, but they were a heavy set of regulations were placed on them to make sure that those companies were not able to exercise their power at that choke point in the middle of kind of our meat supply chain to manipulate markets and affect fair competition. And by the 60s, the industry was fairly deconcentrated. The top 4 companies in the meat industry in the middle of the 20th century controlled about 20% of the market. But over the past 40 years, trend has reversed, and now we're back to an environment where in every kind of meat industry, top 4 cluster of companies control anywhere between 50 and 80% of these various sectors. We're talking about poultry today, but this is a common issue with different kind of quirks in pretty much every sector of the food system. So the Packers and Stockyards Act specifically was designed to prevent large meat corporations or really anyone involved with kind of the meat supply chain from utilizing their power as buyers and sellers to give unfair preferences to large farmers or other entities that are a part of the supply chain, from manipulating the market, from buying up or vertically integrating too much of the market. And it was successfully enforced for many years. But because that enforcement power has waned over the past 40 or 50 years, we are where we are at today. And so that brings us to this year. And one of the big priorities of the Biden administration has been an attention across the entirety of the government on enforcing fair competition in the economy. And one of the ways that the USDA is responding to that executive order to pursue fair competition rules and regulations throughout the economy is this newly rejuvenated attempt to finalize a new set of rules related to enforcement of the Packers and Stockyards Act. And that's called a rulemaking process. So just really quick, what is a rulemaking process? Basically, Congress creates laws, and if they are passed and signed by the president, then it's the job of the various agencies in the executive branch of the government to actually enforce the laws that have been written and signed. So if it's a law saying we're going to invest in a bunch of meat processing plants, USDA takes that money and they design a grant program and they give out grants to people who want to start processing plants, and that's them enforcing the law. In the case of the Packers and Stockyards Act, it's a law that is setting out a set of rules for the market, and it's the job of the USDA to enforce those rules. And if people are breaking them, sue the people who are breaking them and take them to court. And then in those court cases, the courts decide whether those folks have broken the law. And based on whether they have or not, they enforce penalties. So the rulemaking process is the agency that's charged with enforcing that particular law, telling everyone in the country, hey, we've gotten this law from Congress, here's how we're going to enforce it. It's also basically them setting policy for their internal operations. So if the USDA says we're going to enforce the Packers and Stockyards Act in these ways, we're going to pay attention to these abuses, we're going to update which abuses we pay attention to in these ways, that's basically saying to the actual department of people in the government, hey, you need to pay attention to this now, or you need to give more attention to this type of problem that didn't used to be there, et cetera. So there are three main rules that Secretary Bill Sack has said in public hearings before Congress that the USDA is working on this year. The first is highly relevant to the poultry industry because it is called the transparency let me get the exact title. It's a rule about tournament systems, and it's called the Transparency in Poultry Grower Contracting and Tournaments rule. This rule was worked on throughout the beginning of this year, and it's currently been finalized by USDA, and it is being reviewed by the Office of Management and Budget. You don't need to know a lot about that other than that. Those are the bean counters, the accountants of the government. It's their job to look over any kind of policy that's being proposed by an executive agency and see what effects it's going to have on how much money it's going to cost to enforce, what effect it's going to have on the economy. We anticipate that that rule will be released sometime this month, just based on how long it generally takes OMB to review rules like this. And so when that rule is released, we'll know, publicly for the first time what USDA is actually proposing as this first rule on how they are going to improve their enforcement of fairness in relation to tournament systems and improve the transparency that we have over how poultry contracts work and what's allowed in poultry contracting. So what we have been advocating for years at RAFI is that poultry growers should be compensated in their contracts in a fair way that is based only on factors that are within their control. And we would contend that tournament systems base your payment on factors that are in other people's control, whether that's your integrator or whether that's other growers in your tournament pool. We're all for bonuses. Performance bonuses are great. I've worked at plenty of companies that have performance bonuses. Performance bonuses can be designed like a track and field competition where you're competing against yourself or against a set of standards. And if you do well, you get a bonus. And if you don't, you just get your base pay. That's kind of how it works in a lot of companies, but that's not how it works in poultry, right? In poultry with the tournament system, if you happen by a quirk of fate to be put with a different set of growers in a given tournament pool, that could really affect whether you are above or below average. We don't know for sure what standards USDA will be setting out in terms of what is fair in tournament systems and poultry contracts. I'm just telling you what we at RAFI have advocated for years. And it remains to be seen exactly how they intend to improve the fairness and equity of how compensation is delivered to poultry growers in their contracts. But you do see in the title of that rule, transparency in grower contracts, that they're also very interested in increasing the transparency around what factors are affecting grower pay. So we'll have a lot more to say on the contents of that rule once we know what it is. There's two other rules that are coming out. One will be kind of a broad collection of updates to what constitutes an undue preference or unfair practice in a variety of livestock and poultry industry, sectors. There will be things relevant to poultry. There will be things relevant to beef, to pork. So specifically with poultry, some of the things that we expect to see and hope to see would be updates to what constitutes retaliation and stronger standards for how packers and stockyards will investigate and enforce anti-retaliation regulation and protect the ability of contract producers and any
I think we may have lost Aaron just for a second here, but hopefully he'll be right back on. Hopefully everyone is enjoying this great breakdown that he is giving us of the PSA and what the proposed changes could mean for farmers and ranchers.
Can you hear me now?
Yep,
Yeah.
you're back.
I could hear you the whole time. So I was just reviewing a couple of different things that could be a part of the second rule around undue preferences and unfair practices. Some other unfair practices could be kind of offering a take it or leave it renewal to your contract based on requiring you to do mandatory upgrades. That's definitely something that we're going to be advocating closer attention to. There's really kind of a grab basket of things, but I mean, this is an over 100-year-old law, and the industry's changed a lot. And so they need to kind of look at the industry today and ask what are ways in which large meat packers are giving undue preference in the economy. What are ways that large meat packers are enacting unfair practices, and kind of list those out and say, if you keep doing this, we're going to bring cases against you in court and enforce fines or basically take action against you. And then the third rule is seeking to clarify that private individuals who seek to bring a lawsuit, or the Packers and Stockyards Division, when either a private individual or the Packers and Stockyards Division brings a saying that there's a violation of the Packers and Stockyards Act, that the Packers and Stockyards Act does not require either of those to prove competitive injury overall in the marketplace as a burden of proof for their case. That was a lot of word salad, so let's try to understand what that means. Basically, right now, over the past 40 years, a legal doctrine has developed in the judicial system that is not actually mandated by the Packers and Stockyards Act's text, but has become the standard practice of judges within the judicial system to require either the Packers and Stockyards Division or individual contract growers who are suing a meat packer and saying that meat packer is violating the Packers and Stockyards Act. Currently, judges will require you to try to prove that your specific case represents a threat to raise prices for consumers all over the country, or in other ways dramatically affect competition in the national economy. And the reason why that's ridiculous is the same reason why it would be ridiculous if you were, T-boned at an intersection and suffered an injury and decided to sue the reckless driver who hit you. And the judge said, well, you actually need to prove that this driver's behavior is going to affect every driver in the United States of America. Well, that driver can't be everywhere in the United States of America at one time. That's a ridiculous burden of proof. You were injured, and the law should protect you and give you recourse if you are injured unjustly. And that's exactly what the Packers and Stockyards Act does actually lay out, we would contend. And so one way to strengthen the case or the ability of individual contract producers or the USDA in enforcing this law and bringing cases to court in the future would be for USDA to clarify that it is their position that the Packers and Stockyards Act does not, in fact, require that burden of proof. So that's the significance of that third rule, which has been a barrier to enforcement of this law over the past few decades. So those are the three rules. We anticipate them to be released throughout the year, starting with this tournament system rule, hopefully this month. Another significant development in relation to all of these things is the USDA announced earlier this year a kind of joint effort with the Department of Justice to streamline the way that they process complaints related to antitrust law. And they announced a new portal online that anyone can report, specifically any agricultural producer can report violations they think they have observed or experienced that constitute a violation against antitrust law, including the Packers and Stockyards Act, also the Sherman and Clayton Acts. I've written a pretty in-depth kind of explainer and FAQ about this system, but just in brief, you are able to go onto this portal and give an account of a violation you think you've observed or experienced related to the Packers and Stockyards Act. You can either do that with identifying information or anonymously. If you submit anonymously, the regulators at the Packers and Stockyards Division are a little bit more limited in being able to investigate it because they can't ask you follow-up questions. So it's important to be as detailed as you can. If you do provide identifying information, your privacy is protected, including from FOIA requests. If an outside actor, including an integrator, were to make a freedom of information request of the USDA regarding submissions to that portal, they are authorized to redact your identifying information from their response to a FOIA request. But if they eventually seek to bring your case to court, they will be having a conversation with you about whether you're willing to testify. And so at that point, you'll have to make a decision about whether you want to pursue that course of action or not, hopefully in conversation with legal counsel. But in any case, it's helpful to report what's going on in the industry. So even if you do that anonymously, that's helpful to them. And there's some pretty robust whistleblower protections associated with that now. That will become an even more effective tool on the other side of these rulemakings hopefully being finalized, because then there will be an expanded set of things that you can actually complain about. But if you want to learn more about what constitutes a thing that you should complain about, or what privacy protections are there, or any other questions you have, you can look at the blog article that Julie will be posting in the comments. I've also written article kind of explaining this rulemaking process described, if that's helpful to review, and that's also going in the comments. So that's kind of the state of things right now. And as these rules are released, we'll be doing a lot of break them down and explain them to the, and then also once these rules are released, there will be a comment period, basically, where they are asking anyone to tell them what they think of the rule. And then based on that feedback, they may improve it, make changes based on kind of feedback from a variety of folks. The industry will be submitting to that comment, and they will be complaining so much about how this just makes their life so hard. And it's important for us to also submit feedback to the USDA about why these rules are so important, and if there are any ways that they need to improve them. And I can talk a little bit later about ways we're planning on doing that. But I'll stop for now so that we can do some Q&A.
Yeah, thanks, Aaron. That was an amazing breakdown of the act and what it means for farmers, and just really good information for people out there. I initially, at the beginning of these lives, let people know that they can put questions in the chat. However, I did not do that today. So if anyone listening does have any questions, feel free to throw those in the chat now. We'll give people just a few seconds, a minute or two, to see if they have anything that comes to mind. But while we're waiting for that, we do have one question that's ready to go. And one of them that folks would like to know is that basically these rules, they already make a lot of sense. These rules make a lot of sense. So why aren't they already on the books? I think you're on mute, Craig.
Yes, I was on mute. Well, they are on the books. It's the enforcement that's kind of been lacking. I mean, it says plain as day in the act that you can't do deceptive or discriminatory practices. It says these things, but what has happened is that there's the poultry, like I said, there's a few little quirks to it. The farmer not owning the chicken kind of puts a little different spin on it, but at the end of the day, it's you've had a law that has not had a facelift and kind of kept up with the changes in the industry. And then this harm to competition thing that Aaron was talking about, I mean, that really just kind of just throws water on. I mean, it's an impossible standard. I mean, if they went down there and they did something to Michael Diaz that was deceptive or discriminatory, and he brings a case under the PSA, he has to prove that it affected the price on the shelf in every grocery store, every piece of chicken in the United States of America. It's not going to happen. So they pretty much have lobbied and influenced the way. If you've ever read The Wealth of Nations, they warned about monopolies and monopolies, that it leads to political influence, and right on the edge of that is corruption. So I'm not saying it's led to corruption, but there's certainly some political influence here, and these integrators, they swing a very big stick. So it's not a matter of laws aren't there. They just need to be tightened up, and they need to be enforced. And that's what I'm excited about, that it seems that this is what is happening now.
The other thing that I'll just add is that sometimes laws are written really specifically, and sometimes laws are written in general terms, and there's strengths and weaknesses to both. One of the strengths of writing a law in general terms, like the Packers and Stockyards Act is in some of its measures, is that it allows for interpretation as things change. But for that to work, you have to actually keep interpreting how the law should be enforced as the economy changes. And so that's what this is about. And part of the problem is, in any given administration, there are decisions about whether that's a priority or not. And in this administration, there's been a decision has been made that this should be a priority. And so that is why we are trying to update it now. So that's something else I'd add there.
Thank you both for that. Another question that we have is, what could get in the way this time of these proposed changes?
So as we all know, the midterms are coming up, and there is a chance that majorities will change in Congress, depending on, your optimism or pessimism and where you are on the political spectrum. You may think it's more or less likely, and be happy or sad about that. But in terms of how that's relevant to this issue, you heard Craig talk earlier about how something called an appropriation rider or a GIPSA rider has been used to derail this process in the past, and that is something that could happen again. So what that means basically is we can make whatever rules we want, but ultimately we, the people, have to pay someone to do this, and that's the Packers and Stockyards division at AMS. And if we want them to do a really good job, then we need that department to be fully staffed with a lot of smart people who are out there looking for people who are breaking the rules and trying to do something about it. And if we don't want that to really happen, then we will kind of de-staff that department and make them operate on a shoestring budget and not fully fund their operations. And then they'll have to decide to only enforce the law on a few cases because they only have so much resources. Like this takes time and money and people who you have to pay so that they can make a living. And the budget for that is controlled by Congress through the appropriations process. And so USDA will go through their process of making these rules. And in the meantime, we hope and we're advocating to USDA that they need to be moving quickly and finalizing those rules this year. Whether or not they're able to do that, we don't know. In any case, over the next year, we'll see what happens in Congress. And there are definitely constituencies within Congress that are opposed to this rule or these rulemakings. And many of those members also have deep ties financially and through political contributions to the meatpacking industry. And all of those industrial players, all of those corporations will be spending lots of money on lots of lobbyists who will be screaming from the rooftops about how this is a bad idea. And if the landscape of power in Congress changes, it's possible that a new majority will attempt to create an appropriation rider again, which basically means there's a time in the kind of the congressional season. They're like, okay, let's get our calculators out and decide how much money we're going to give to all these different departments to do their jobs. And someone's going to be like, you know what? Let's not give Packers and Stockyards Act enforcement any money. And that way, it doesn't really matter what rules they made. They're not going to really have much money to do anything about it. And if that happens, there's going to be a bunch of people in these big corporations that are super happy that they don't have to worry about there being a department in the government that is going to look over their shoulder and make sure they're not breaking any rules. And it's important that we use our voices as much as possible to tell those representatives in Congress, whoever they may be, that that's a bad idea, that we actually need that department to have the funding it needs to do their jobs and enforce the rules so that we have fair markets. So it remains to be seen whether that becomes a barrier that we have to overcome, but it's definitely possible.
So what confidentiality and retaliation protections are available to those who submit complaints through the Farmer Fairness portal that you mentioned, Aaron?
Yeah, so talk about that a little bit. You can go to the article that we linked, and there's actually a few links in that article to other things that you can read. Submissions to that portal are protected by a different congressional act that protects whistleblowers. So that's a relevant protection. Additionally, like those submissions to that portal are confidential. If your privacy is going to be most protected if you submit anonymously. We talked a little bit about how that can affect to what degree they can take action on your complaint. If you do identify yourself, they will basically be doing everything in their power to keep you confidential for as long as possible. And they do have some ability to redact your information from FOIA requests. But the further along you get in that process, which like on the one hand is exciting because you have a case, the closer you will be to having to appear in public records or in court. And so that's a consideration you have to make for yourself. And that's definitely, if you're in that process at that point, that's definitely a situation where you probably also want to be talking to a lawyer because they can provide valuable insight on what risks you're exposing yourself to and how to conduct yourself.
Okay, great. And yes, we put that link in there to the Farmer Fairness Portal Act, so people can learn more about that. And finally, we have one last question, and it's probably one of our most important, is what can people do? What actions can they take? So
at RAFI, we're currently kind of building up a policy action network, we're calling it. And so Julie's also going to be putting a link to a registration form to register for that. Our policy action network is our way to stay in touch with people who want to receive updates about policy that's relevant to them, and also our way to let you know if there's things you can do or be involved with in relation to this process. Specifically for these rules, we recognize that in the past, folks have gotten involved in this process, and in the process of doing that have become their involvement in advocating for change has become public, and some people face retaliation. We want to try to prevent that as much as possible. One of the ways that we're trying to do that is when these rules come out and have things that are relevant to poultry growers or other contract producers that might face risk of retaliation for using their voices, we're going to be creating an anonymous survey that we will push out to our policy action network, that we will share with SRAP, and we'll be sharing it on our social media. SRAP will be sharing it in their networks, and that survey will allow you to give RAFI-USA your feedback about the rule. So we'll write a blog. Here's what the rule says. Explain what it does. And then we'll create a short survey that's asking some questions about your thoughts on the rule based on how we've explained it. What do you think about what the USDA is doing here? And also some questions about how have you experienced unfairness in relation to the tournament system, or how have you experienced other forms of unfair practices or retaliation, whatever the case may be for any of these particular rules. You will have the choice of whether to identify yourself to us or not. So you can even be anonymous to RAFI and provide feedback, or you can let us know who you are. Either way, that survey information we will aggregate, we will put it together, and we will present it completely anonymously to USDA. So that means that your name will not be in the public record. You like the fact that you provided a story or your feedback on the rule will not be traceable back to you, but at the same time, you will still be able to make your voice heard kind of, by extension through RAFI as we make our comment to USDA. And we know, based on our conversations with folks who are actually involved in this rulemaking process in USDA, that they are anticipating that responses to that survey with great interest. They also realize in the department that retaliation is a major issue, and that it is difficult for specifically active growers to get involved in this process in the current environment. And so they are going to be taking that information that we provide them as kind of an intermediary really seriously. So if you want to be on the list to get updates when this rule comes out, if you want to be on the list to receive a link to a survey like that, to be able to complete that, give us your feedback that we can submit anonymously to USDA, and sign up for our policy action network, and you'll be kept up to date, and you'll have a way to make your voice heard while retaining your privacy.
Awesome. Thank you so much. That was such great information and really good action items. We're really grateful to have you here today to share that with people.
I'll add one other thing. To the degree that you're comfortable with it, talk to the people you know. There's nothing more effective than talking to people who you trust about these issues, that you trust them, especially with some of these issues. But like, it's important that people on the ground are talking to each other and are in solidarity with each other. Importance of us working together to have a fair economy, and even if that's not specifically about this, right? Like, voting is a part of this. Thinking about how these issues affect our lives and how that applies to our politics, like all of that is important too. So I think there's a lot of room for us to be talking to each other in our own communities about how these issues affect our local communities, our local food economies, and our lives, and our economy overall.
Yeah, absolutely. Great point. Talking to the people closest to us can sometimes make the biggest impact. So unless anyone else has anything they'd like to add, we're going to wrap up here today. I just want to remind people, if you're new to SRAP, we protect communities from factory farms. So if you are facing a factory farm, we have the link in the chat for our help hotline. So please check that out. And we also want to let you know that we have episode 4 coming up in this Facebook Live series. It airs May 24th at 4 p.m. Central. And we're going to be talking banks, loans, and guarantees. So tune in and join us as we uncover how these multi-million-dollar mega farms are getting financed with loans that are guaranteed on the good faith of a single piece of paper. And how can they really be guaranteed based on that? We'll be setting up a Facebook event for that soon. So please stay tuned to our Facebook page, and also to keep up with SRAP and our work that we do. Please sign up to our newsletter, and you can do that by visiting our website, which is sraproject.org. And yeah, I think that does it for today. So thank you, everyone. Thanks, Aaron. Thanks, Craig. Thanks, Michael, for joining us, and everyone else who tuned in. And this video will be going up on our website in a few days. So if you missed it, it will live on our Facebook page, and it will also be on our website. So thanks again, everyone. And we look forward to talking with you again soon.
Thank you, Aaron. Thank you, Julie. Thank you, Craig. Bye-bye.
Bye.